Okay, welcome everybody. Thank you for joining us today for our training on investigating complaints of harassment and discrimination. I'm Lori Rawlings, the Executive Director of PMCA, and I'd like to introduce our guest speakers today. Nicole Farrup is the principal and owner of Good Company HR, and she provides customized human resource guidance and support and training for companies of all sizes and industries. And Allison Kruger is an employment lawyer at Dunn Carney here in Portland. She's been practicing since 1996, and a significant part of her practice focuses on helping employers navigate the ever-changing landscape of employment laws in Oregon and Washington. I'm going to start with a few housekeeping items. Just a disclaimer, although there is a lawyer on the call here, we're providing general information, a general overview. We're not intending to be giving legal advice, so nothing we say here should be construed as legal advice. If you need legal advice, please consult with your attorney. To facilitate an efficient meeting, I'm going to ask people to mute if they are not speaking. And if you have questions during the course of the presentation, please use the chat feature to type those questions, and then I will keep a running tab on them and ask our presenters those questions as we go along. If you want to submit your question anonymously, you can do that by submitting the question directly to me rather than to everyone using the chat feature. We're recording today's session and it's going to be posted on the PMCA website. So if you don't want to be featured on the PMCA website, feel free to turn off your video. And finally, I'm going to turn it over to Nicole to walk us through the presentation. So thanks again, everyone, for being here. And I'm going to turn the screen over to Nicole.
All right. Thank you so much, Lori. Hi, everybody. So let's see. So here, I'm going to share my screen here with you all. We're going to go through some slides. We're going to go through a few slides. Forgive me while we get it. It's completely set up. There we go. So we're going to go through, share some slides with you. We think that's a great way to address the main points of this topic. So welcome. Today is the Complaint Investigation and Response Review guide, and we're going over the guide that I believe Lori may have sent out with the invitations. We're going to kind of briefly touch on some of those topics as well as changes in the law. So, oh, please forgive me. There we go. All right, so hello and welcome. So we're going to start off with recapping the law, and then talking about some of our steps through going through an investigation and things that you need to know, as well as some common issues. So the question is why now? Why are we talking about this right now? Because there have been some recent changes in the law. The Oregon Workplace Fairness Act now requires employers have a well thought out plan for responding to potential harassment and discrimination complaints in the workplace. This was in response to the Me Too movement. It was passed in June of 2019 and takes full effect October 1st in just a couple of days, October 1st, 2020. In addition, it's really important to start developing a more thought out and thoughtful process for addressing complaints to discrimination and harassment, because current social movements such as Me Too and Black Lives Matters are generating a lot more awareness, and some of you maybe are already seeing more complaints, more questions, requests for responses, and things like that. And so it's generating more awareness for our employees about discrimination in the workplace. So we want to have a really great process for addressing these things, not only for compliance for the law, but because our employees are demanding it. Oh, shoot. You guys, I'm so sorry. I'm having a little technical difficulty, but there, I think we got it figured out. So first, I'm going to hand this over to Allison. She's going to share with us a little bit more about the Oregon Workplace Fairness Act and the background. So, all right. Thank you, Allison.
Thanks, Nicole. Okay, so let's start out with a little bit of a primer on Oregon employment law. As I'm sure many of you know, under Oregon law, there are a number of kinds of discrimination that are considered unlawful. And usually that involves discrimination based on membership in a protected class, such as race or sex, age, disability, and there are many others. In 2019, as Nicole mentioned, the Oregon legislature passed a new law called the Oregon Workplace Fairness Act that made a number of changes to existing Oregon law concerning harassment and discrimination. And I'm just going to cover some of those changes with you. There's a lot to the law, and we could probably spend an hour just going over the changes in the law. So I'm going to try to go through this relatively quickly. So the Oregon Workplace Fairness Act applies to all employers of any size, and that includes public employers, private employers, and whether they have a union involved in their workplace or not. And it covers discrimination and harassment based on all protected classes under Oregon law: race, color, religion, sex, sexual orientation, national origin, marital status, age, military service, disability, and, believe it or not, expunged juvenile record, which is a rare one that I've not seen much of in my career, but I suppose it comes up from now and again. And it also includes and describes conduct that is referred to in the new law as sexual assault, which is something new. Previously, Oregon law, of course, prohibited sexual harassment, but now the law has been changed to define sexual assault as prohibited conduct. And sexual assault is defined in the new law as, quote, unwanted conduct of a sexual nature that's inflicted upon a person or compelled through the use of physical force, manipulation, threat, or intimidation. So I see this as just more fully defining the type of harassment that we used to call quid pro quo harassment, or, you know, have sex with me and I'll promote you, or if you don't, I'll make sure you get fired, that kind of thing. But it can cover a lot of other behaviors too that I think previously would have been prohibited in the law. This just more provides a more a different type of definition, I guess, is the best way to describe it. Also, the law imposes new requirements and restrictions on employers aimed at combating harassment and discrimination, and it greatly expands the ability for those subject to harassment and discrimination to pursue remedies through either litigation or administrative complaints with the Bureau of Labor. The Act also has some changes in it that makes certain things that employers have done for forever, which has always been fine, to now be illegal. And what those new unlawful employment practices are asking employees to enter into severance agreements or other types of employment agreements that include non-disclosure or non-disparagement provisions that might prevent an employee or a prospective employee from disclosing or discussing prohibited conduct. So, and that would include prohibited conduct occurring between employees or between an employer and an employee. So this would be a management level employee and an employee in the workplace, even if they occur at a work-related event off the employment premises, or where they're coordinated by or through the employer, or that occur between an employer and an employee off the employment, well, I mentioned that, off the employment premises. There are some limited exceptions, but basically what this restriction is that an employer can no longer ask an employee to sign a severance agreement or some other form of employment agreement that would restrict the employee from talking about their own experiences in the workplace involving discrimination or harassment. And for those of you that have used severance agreements in the past, you will want to have those documents revisited with your employment counsel to make sure that they do not run afoul of the new law, because just asking an employee to sign a severance agreement with a non-disparagement provision in it, a standard non-disparagement provision, is now, as of October 1, will be an unlawful employment practice that you can be sued for. So this is a really significant change that everyone needs to be aware of. There is some exceptions to all of that, in that an employer can enter into an agreement with non-disclosure, non-disparagement, and no rehire provisions if the employee requests it. And if they request it and it's included in the agreement, then they have to be given 7 days to revoke once they sign it. So it gets pretty complicated, and it's just something that I think a lot of employers are not going to be aware of this change, and they're going to end up, wandering into this mistake, and potentially they could be sued for that. Another major change, and I think the change that is most relevant to our discussion today, is that the Oregon Workplace Fairness Act requires that every employer adopt a written policy that contains procedures and practices for reducing and preventing protected class discrimination and harassment. And in the past, having a harassment and discrimination policy was considered a best practice, and it would allow an employer to use a particular defense under federal law. So there was no law requiring that employers have policies, but that, as of October 1 in Oregon, that has changed, and now employers are required to have a written policy. At a minimum, the policy has to provide a process for employees to report prohibited conduct. It has to identify an individual as well as an alternate individual designed to receive those reports, such as someone in management plus human resources, or even a couple of people in management plus human resources. It has to include, the policy also has to include the statute of limitations period applicable to an employee's right to sue for such prohibited conduct. And it also must include warnings about the employer not being allowed to require or coerce an employee to enter into non-disclosure and non-disparagement agreements. And also the revocation period. So all of this information has to be in your policy. No one has this in their policy. This is completely new. And so every employer in Oregon needs to revisit their harassment and discrimination policies. Additionally, the new policy has to be distributed and made available to all employees in the workplace. And of course, a lot of employers may have people working remotely. Those people should receive a copy of the new policy by email, and everyone else should also receive a copy either by email or physically. And then any new employees have to receive a copy at the time they're hired. And additionally, and this again is a big change, the OWFA requires that the individual designated to receive complaints must provide a copy of the policy to an employee at the time that the employee discloses information regarding prohibited conduct. So if an employee comes to one of the designated individuals to report discrimination or harassment, the person receiving the complaint is supposed to provide a copy of the policy to the complaining employee at that time. There's another little piece of it where the law allows employers to void severance provisions basically these would be in sort of executive employment agreements if the executive or the employee is terminated and there's a substantial contributing factor was that they had engaged in conduct that's prohibited under the Oregon Workplace Fairness Act. Again, this is one of these very complicated aspects to the law that most employers are going to want to consult with their employment counsel on. Finally, I think I mentioned that the policy has to provide information about the statute of limitations, and what the Oregon Workplace Fairness Act does, one of the things it does is it extends the statute of limitations from 1 year to 5 years. So this is a very, very significant change for employers to have to deal with. This means that, 4.5 years from October 2nd, you could have a claim filed by an employee, dating back to 2020. And you're going to want to make sure that you retain the personnel records of all employees. and any other documents related to the employee's employment for at least 5 years. So this is really a significant change in the law. And my guess is that Oregon will have one of the longest statute of limitations when the law becomes effective on October 1st. So big changes and a lot to be aware of. Thanks, Nicole.
Thank you so much, Allison. And it makes it even more important, I think, with these changes, then it makes our conversation today even more important, because you do really have to start, employers really should start encouraging managers to really confront issues that are coming up in the workplace pretty proactively. Let's see here. There we go. So you can also find here, following this link, and you'll receive a copy of the slides, I think, as Lori mentioned earlier, you'll receive a copy of these, and you can follow this link here that we provided to the Bureau of Labor and Industry's No Discrimination or Harassment Model Policy, as well as their guidance. It's a really great policy, and you can adopt it pretty much in whole. I think Lori's also sharing a copy of this with you, just so, you know, if you can use that, or you can follow the link as well. So, okay, so with that, let's get started on the guidebook. So the guidebook, if you have it handy, you can refer to it as we go along. We're going to be hitting the highlights of what's in the guidebook for you, for how to develop your process. So when you're developing your process for responding to complaints, to get started, you want to be prepared before your next complaint happens. You want to start thinking about when to respond. When do you respond to complaints? And the answer to that is every time. And you want to develop a neutral mindset. And the reason that I highlight this here is because we know our employees. It's not uncommon for employees with, behavior issues to come forward with complaints, or if they're in trouble for something, to come forward with complaints. We also have our own biases, or we think we know people. And so, sometimes that prevents us from thoroughly investigating, because we think we think we know what's already going on. So it's really important to kind of develop a neutral mindset and compartmentalize. And anytime a complaint comes up, let's investigate or address it in the most appropriate way. So your first steps are, anytime a complaint is made, you want to ask these certain questions. You want to do an initial intake, focus on the basic information. So what happened? Were there any witnesses? Is there any evidence to preserve? And evidence to preserve is going to include things like emails or notes on my locker or text messages or Facebook posts. Because remember that social media can be a tool for harassment and discrimination in the workplace as well. You don't control what people, of course, put on their social media, but if they're using it, social media as a tool to bully or harass or discriminate against others, then it can be. It is something that we want to know about. And you want to, most importantly, the most important question you want to ask folks when they come with complaints is, what would they like to see? What would they like to see happen? And definitely make a note of that. You always want to thank people for coming forward. That's really important. It's hard for most people to come forward with complaints. It usually takes a lot of courage. And I'm sure some of us have seen this, employees cry, they cry or get upset, they turn red, so it's really hard for people to come forward in most cases. So you want to always thank people. You also want to remind people that retaliation is prohibited. Retaliation, and Allison, you can comment on this if you'd like. Retaliation is probably the #1 basis for EEO and bully complaints. It certainly is. If it's not #1, it's #2 for sure. So you always want to remind people of that. And then last, as Allison mentioned, you want to make sure that you do have a copy of your no harassment and discrimination policy that informs them of their rights. You want to make sure that anytime people come to a person who is reporting, and we're going to talk in a minute about, well, what if they go to their manager instead of the people who are listed, the roles that are listed in the policy? We'll talk about that in a minute. But if you're HR person, or you are in the designated reporting person that people would come to with alleged harassment or discrimination complaints, you want to make sure you're giving them a copy of that policy. So Allison, is there anything you wanted to add?
Yeah, just a couple of points. First of all, of course, your policy, harassment and discrimination policy, should state specifically that the company does not tolerate retaliation. And if you are the person who's receiving a complaint of harassment or discrimination, that complainant needs to be told that the company prohibits retaliation. And if they feel, at any time that they're being subjected to retaliation, that they need to come and see you immediately. And we'll talk a little bit more about how that will be repeated throughout the process of an investigation, that everyone is aware that retaliation is not tolerated. As Nicole mentioned, one of the most significant areas of complaints to the Equal Employment Opportunity Commission and also to BOLI are complaints of retaliation. So someone has reported harassment or discrimination, and maybe the employer investigates and there's not enough evidence to substantiate that there was any harassment or discrimination, but then the employee who complained is demoted, or their shift is changed, or they're terminated. And so they claim that they were retaliated against for complaining in the first place. And it doesn't matter whether their complaint was substantiated or not, or whether there's even evidence of discrimination. They're protected from retaliation. And so if something negative happens to them at work shortly after they have complained, you're likely to see a complaint of retaliation coming in through, either an administrative agency or potentially a lawsuit. So it's really important to be aware of that. Let's see, what else? Nicole mentioned, well, I guess we were going to talk about that a little bit more, but what happens if a complaint comes to someone other than the person designated? So we'll talk about that on one of the other slides. Thanks, Nicole.
All right, thank you. Okay. So next, we have a couple of questions. So these are some things we wanted to, that are really important that come up on, we're going to go through a number of questions on the next few slides, because these are things that come up regularly. So beginning with, what if a person making the complaint requests confidentiality? Do I have to guarantee that? And this happens all the time. And from an HR standpoint, what I can tell you is, no, unfortunately, you cannot guarantee confidentiality. You can ensure it to the greatest extent possible, but you can't actually guarantee it. And you want to be careful about guaranteeing people confidentiality as well. What you can do to make people feel more comfortable is support them and make sure that you remind them that you're not going to tolerate retaliation. And that you will only, you'll keep it confidential to the extent you possibly can, but that you can't always guarantee that. Allison, do you have anything to add to that?
Yeah, I would just add that, the complainant needs to understand that they're coming forward with information that you or someone else in the company is going to have to investigate. And so it can't be kept confidential entirely, because it can't be investigated if it's kept entirely confidential. So there are going to be people who it has to be disclosed to, but those would just be the relevant, parties and witnesses and so on. So it's just important to make sure that complainants understand that.
Yeah, absolutely. And I think that goes right into the second question is, what if they want to make complaints anonymously? Do you still have to respond? And the question for the answer from an HR standpoint to that is probably. Yes, probably. You are obligated, even if someone comes forward and says it's an anonymous complaint, you should still look into it to the best of your ability, because there is no unringing of a bell, so to speak. So if it's something you know about it, and you have to, you're obligated as the employer to address it. And what the Oregon Workplace Fairness Act makes more clear than ever before is that employers are, you really do have to change that mindset of like, if I don't talk about it, or if I just ignore it, it'll go away, or, oh, well, whatever. It's just, people being people, you should respond. So, so the last question, and then Allison, I will ask you to make give some feedback on both these points, is what if the person making the complaint only witnesses the interaction, but they weren't directly affected? So it's a third party complaint. Does the person directly affected have to make a complaint as well? And the answer to that is no. It is a long held, it's a long established standard that people can still experience harassment or discrimination, but not be the target of it. And it's not uncommon that then when you go to the person being directly affected, for them to say, hey, I don't want to do anything about this. That doesn't, you should still respond, because it's the person reporting who's experiencing the issue, and you still have an obligation to respond to that. So Allison, do you have anything else to add?
Yeah, I guess I would just add that, you know, on the question of what if someone wants to make a complaint anonymously, you know, if they come in and that's the first thing they ask, I think the answer is sort of similar to the, can I make this confidential? You know, sorry, but I'm willing to hear anything you have to report, but I cannot guarantee that you will remain anonymous in this. For the reason Nicole mentioned, you can't unring the bell. If you bring me information that I have a legal obligation, the company has a legal obligation to look into, we're going to have to do that. And that means, you know, who reported it initially may come out. And, you know, then you just have to allow the person to decide whether they want to continue talking. As far as what if the person making a complaint only witnesses an interaction but wasn't directly affected, and does the person directly affected have to make a complaint? No. And that's true even if the person who observed the interaction but wasn't directly affected doesn't feel like this interaction subjected them to some sort of harassment or hostile work environment, but they're just bringing it to the attention of the employer because they have a concern about what's going on between their coworkers. That is still information the company is aware of, and the company does have a legal obligation to look into those issues, even if the directly affected person has not come forward.
Yeah, absolutely. Okay, great. Thank you. All right, so next, what about this scenario? This is what we were referring to earlier. So employees are going to report to someone that they feel comfortable with, and our current policy, not the new policy we're going to adopt, says that they can go to anybody that they do feel comfortable with. Does every manager or supervisor need to be trained? And as I shared earlier, no, they don't all have to be trained in how to conduct an investigation, or that they have to give out a copy of the policy, or things like that. But what you do want to train people in is a couple of things. You want people to have a problem-solving mindset, and you also want to have relationships with all your managers and supervisors where they are you're talking to them regularly, and that you have trust and rapport, so that if issues come up, you hear about it, that you know about it, and that you have the opportunity to address it. Because there is no such thing as if your manager knows about it but never told you about it. That's your manager is acting as an agent of your organization, and so that's not a defense for the company that, oh, my manager or my supervisor didn't properly run this up the flagpole, so to speak. Well, that doesn't matter. And so it is really important to, this question in particular, I think really illustrates for me kind of a shift. I think something that I hope everybody is already doing, but definitely a shift, is we want to have a problem-solving mindset, and we want to have more lines of communication open, particularly so we know when things are coming up and that we can prevent them before they turn into potential harassment or discrimination. So Allison, did you have anything to add?
Yeah, I mean, I strongly suggest that any employer's harassment and discrimination policy contain either the titles or names of the individuals who are authorized to receive complaints. Because even though employees might just go to their manager with it, what you want for those managers to know who to go to with the information that has been brought to them. So you don't want them undertaking their own efforts to try to investigate or to try to remedy the situation. But they need to understand that there are just a couple of people within the company that really are authorized to receive complaints. So not to discourage employees or say, go see one of these other people, because I think any manager should be able to do what Nicole just mentioned, is to listen and receive a basic information about a complaint from an employee. But you want those managers then to go to the individuals who are designated to actually receive complaints. And the other reason why that is important is that under the Oregon Workplace Fairness Act, the individuals who are designated in your policy are the ones who are obligated to then give a copy of the policy to the complaining employee. So this way, you're not having to train every manager on how to conduct an investigation and how to give a copy of the policy, but you can funnel those complaints upward to the individuals who actually are going to be responsible for dealing with the complaint. Yeah. So, minimal training for anyone who manages people on what to do if they receive a complaint, and then additional training for those who are going to actually be the designated persons to receive complaints.
Yeah, absolutely. And I cannot stress this enough. Please have regular check-ins with your staff. Just do it. Just do it. Okay, so in writing, this is another common feature, especially I see this a lot of times in union environments, that employees are currently required to submit complaints in writing. So can you still require that? Well, actually, you know, and you probably never should have. I mean, you can, well, actually, I'm going to let Allison kind of take this. So from an HR standpoint, my response is, no, you can ask them to, submit a written statement, or you can take a statement from them and ask them to verify it. That's always a good idea, because one of the features of the law, and something that's incredibly important, is that you are required to document when these issues come up, and document and keep records of complaints, and you should be doing that anyway. So you can require it that, under those circumstances, that either you can provide it for them to verify, or they can submit a complaint in writing. But you can't require that a complaint comes in writing, or that's the only way you're going to investigate it. So did I capture that all right, Allison?
Yeah, I think so. I see Lori raising her hand.
Sorry, Nicole. Apparently we've got a few people in the waiting room, and you're the host. So would you be able to let some people in? Sorry about that.
Yeah, no problem. Let's see here if I'm able to do that with that. I'm going to stop share really quick to do that. Admit. And then we're going to, there we go. Waiting room.
Thank you so much.
Absolutely. Hi, welcome everyone.
I apologize for that.
No problem. Welcome everyone. Sorry about the delay there. Okay. So back to the share.
No.
I think we might have lost Nicole. Allison, if you wouldn't mind picking up answering the question Nicole just asked you while we wait for her to rejoin us. I'd appreciate that.
Yep, happy to do that. Okay.
Oh, so sorry, you guys.
Okay.
Let's see. Yeah, I don't know what happened. I apologize. So if you'd like to make me the host again, I can go back. Okay. Okay, thanks everybody. Technical glitch. Okay, here we are. Okay. Okay, great. So let's just start here. So welcome, thank you everybody, and scene. Okay, so what do I do? What if an employee says that they don't want me to do anything or say anything? They just want somebody to listen to them, or hold space for them, or provide a safe space for them to talk about their issues, or say that they want to handle it themselves. Can we allow any of this? So from an HR perspective, yes, of course you can. And that is always great. It's great if people can handle things themselves, and you can certainly coach them through that. However, caveat, you do want to make sure that you're following up with them, and that it is happening in a timely manner, and that if it is taking, days or weeks for them to do something, or they are kind of dropping the ball, you want to make sure that you are then following up, because it's the same thing. Just because they've decided that they want to do something doesn't mean that you shouldn't still also address the issue. So sometimes people, are just venting, or they're just, complaining about things, and sometimes we just want to give them the time and space to do that. But what I encourage everybody to do is to kind of switch to a problem-solving mindset. So if people are complaining, there's a problem. Figure out what that problem is exactly, and help them resolve it. And so if they would like to try to do it on their own, that's wonderful. But you must follow up and make sure that it happens in a timely manner. So Allison, did you have anything you'd like to add to that?
Yeah, I guess I would just add that I think it really depends on the nature of the complaint. So, if an employee starts out with this, hey, I want to talk to you, but I don't want you to do anything with the information. Can I just, tell you what's going on? I don't want any action taken. And these types of complaints are semi-complaints are a pretty common thing. And I think you have to tell an employee right from the start that you can't guarantee that you won't have to take action depending on the information that they share with you, that you're of course open to listening to them, but that they may tell you something that the company has a legal obligation to investigate. And then I think the question about what to do if the employee says they want to handle it themselves, I think it really depends on the severity of the incident, because if you just allow the employee to handle it all themselves and it doesn't go well, and you knew about it the whole time and it was something serious, and the employee that was the complainant ends up leaving, I mean, you may end up with a lawsuit and you won't have a very good defense. You knew about some very egregious behavior by a coworker and you didn't do anything with the information and you just let the employee deal with it. And of course the story may change if you end up in litigation as far as what the complaining employee said when they talked with you the first time. So I think it's really important to sort through what's being reported and whether it sounds like something that is serious, and if it's serious it needs to be investigated. What's serious, what's not. I mean, again, that's a whole separate hour-long session probably.
Yeah. Yeah.
But it is something that I think employers need to try to work through before they commit to not following up on directly on any complaint.
That's great advice. That's great, Allison. Thank you. I agree completely. Okay, so now that the complaint is made, you want to create a plan. So planning your responses, who is going to be investigate, who are the people that you're going to designate to that role, and as I know we're going to talk about a little more specifically, is that should be somebody who's trained, and it doesn't necessarily have to be a part of your reporting team, but it should be somebody who's trained or supported. And I'm going to let Allison talk about that in a minute. But next, you want to figure out who's going to be interviewed. And you want to start with the people that it makes the most sense to interview. And you can add people, as it goes along. It doesn't mean that who you're interviewing is just who you're interviewing and that's it. Timing, you want to make sure that your timing is swift. You do have an obligation to investigate things quickly. So you can't let things go for days, weeks, and definitely not months without addressing things and addressing the issue. So your timing should be quick and it should become a priority. You want to determine, the first thing to do, the most urgent thing to do, of course, is determining if an immediate remedy is going to be needed. So does the person, the alleged offender or offenders, do they have to be put on some kind of leave or something, or do they have to be separated? Does something have to be addressed in the immediate need in order to ensure the safety or the well-being of your staff members? Then you want to notify the alleged offender or offenders and take their initial statement. You want to, again, protect against retaliation. And very, very importantly, you must document. You need to document whenever complaints come in. So, Allison, did you want to talk a little bit more about who will investigate?
Yeah, so generally, it's if possible, it's preferred that you have someone internally that can investigate, but that person does need to have some training on how to conduct an investigation. Sometimes if the complaint involves management or is a very serious complaint and you don't have anyone who's really capable of conducting an investigation, then it's appropriate to bring in a third-party investigator, and that will often be someone with HR training, a consultant, or potentially an employment lawyer to conduct an investigation. But as a general rule, I try to encourage my clients to handle the investigations internally if they can, and of course use your employment law attorney as a sounding board and to help guide that process. Again, as Nicole mentioned, it's important to focus on what you might need to do immediately, such as putting the alleged offender on administrative leave, or offering leave to the complainant if they're expressing concern about being in the workplace. Those should be paid administrative leaves, and typically they should be documented. If it's an offender that you're putting on leave, you also want to remove their access to the workplace as well as electronic systems while they are on leave. Again, reiterating the anti-retaliation policy of the company is very important at this stage. And then, as Nicole said, documenting everything that you do.
Awesome. Okay, perfect. Thank you. Okay, so this is a question that I often get is, what do I do if the alleged offender or offenders request a written copy of the complaint? Do I have to provide that to them? And the short answer from an HR perspective is no. You're not required to. You're not required or obligated to provide them with a written copy of the complaint. Just verbally letting them know this is what's happened and this is what's going on is enough. Allison, do you have anything to add?
No, I guess the only thing I would add there is, for a union, an employee is a member of a union. They have a right to request union representation in any investigatory interview. So I would think that a complaint of harassment would probably trigger a request for union representation, or potentially would. So that's just something to be aware of.
Yeah. Okay, perfect. So now the investigation part, and we're just going to go over this very quickly because this is something that that I encourage everybody to spend some time with, really thinking about. So in brief, here's how you conduct your investigation. You'd notify the right people, that may be company management, owners, employment attorneys, or anyone who may not be involved or who may need to know about or support the investigation. And as Allison will share with you, you would engage your employment attorneys when you need support and advice. You don't just notify them, but when you need their support and advice. And that may include other people just when you need their support and advice. However, it isn't something that you want to broadcast to everybody, but owners and stakeholders, oftentimes they need to know what's going on inside the company and be aware of that. And I encourage you always to, whenever you have to include other people who are not necessarily going to be directly involved, they have to maintain confidentiality. It's not uncommon for owners, especially in family-owned businesses or businesses with a family-owned kind of feel, for leadership to have really strong relationships with the workers and the employees. That doesn't, sometimes that with that camaraderie and that friendship, they tell each other things, they tell people things. So you do have to remind people, hey, just because you're a leader or owner or CEO or whatever this company, please make sure this is confidential and don't share it with your lunch or beer buddies or things like that. So that's something that's really important to do, because you want to stop that, prevent the gossip and things like that, because that can turn into a form of harassment and retaliation in and of itself as well. So you want to make sure your questions are planned and consistent. So you may ask different questions of different people, but you want to be consistent with the basic, you want to be consistent with what information you're getting, or what questions you're asking to the greatest extent possible. You want to be open. Don't make assumptions. Don't assume you know what's going on here. The other thing that happens a lot of times in investigations is different investigations come up. So you learn new things and you want to follow all your threads. You don't want to just say, oh, that's not relevant to what we're talking about. Everything is relevant when you start doing an investigation. The other thing that happens is sometimes you think the person making the complaint is the person who's right, and you're kind of, because we feel sympathy and empathy towards those people. So that's really why you want to have a really open mind and not make assumptions, is because you don't want to assume the person that they're accusing of something has actually done that. It's not very, it happens where the person making the accusation is actually the offender. Remind everyone about the retaliation being prohibited. Re-interview people as often as you need to. Document your conversations. Again, I say those things over and over again because that's important. Develop a final confidential summary with remedies. That's something that goes into a confidential file with all your documentation that's not shared with either the complainant or the alleged offender or offenders, but that's just goes into the company file, like, hey, here's everything, here's what we collected, here's our notes, this is what we did, this is how we came up, this is what we came up with. And then you want to communicate resolution to the complainant and offender in a way that's appropriate. And sometimes for the offender, that's going to be a write-up of some kind, or a disciplinary document, or documentation of whatever discipline they're going to face. And then with the complainant, you may want to write them a notice saying, here's what happened, here's what we did, to the extent that it's appropriate. But you don't necessarily you don't want to put anything in their file, their personnel file, about them making complaints. So Allison, what do you have to add to that?
You know, the only thing I would add is that with the complainant, I think it's really important to sit down with them and explain the outcome, and not just give them something in writing.
Yeah.
I think, you know, complainants sort of expect that they're going to be treated humanely, and they should be. And so just giving them a document, I think, is not a good way to wrap up an investigation. But otherwise, yeah, I agree with all of the points that you made, Nicole.
Yeah, thank you for that clarification. I totally agree with that. Yeah, absolutely. So remedies. A remedy is how you're going to respond in order to stop and prevent more offensive behavior and potential harassment or discrimination. These are going to include standard discipline, facilitated conflict resolution, trainings, policy changes, job changes, suspension, or termination. So there's a lot of different kinds of potential remedies that we may have, and it's really going to be what is the most appropriate response to your situation. So one of the remedies that we often see is reassignment. So in the case, because the Oregon Workplace Fairness Act was in response to Me Too, which did uncover there are a lot of what the law refers to as super or, well, the law doesn't, the Equal Employment Opportunity Commission refers to as a super harasser. And those are folks who might be in positions of power who just kind of go from job to job and harassing, and they kind of get let go, but there's a confidentiality agreement, so then they go harass again at another new job. So sometimes there are people who are in positions of power, or there are positions in specialty where they're not easy to move. And so the question often comes up, can I just reassign the complainant so they're more comfortable and I can avoid having to upend my company operations? And the short answer to that is maybe. And which is what that means is that if the complainant would like to be reassigned, if they're not going to face any repercussions in terms of their ability to move up in their career, move up within the company, they're not going to have a loss of opportunity or a loss of money, then, and they agree to it, or it's something they request, then, and they can also request it, but you also want to make sure that when they're requesting it, they're also not losing opportunity or money or things like that, because those things can feel retaliatory, or they may want to think that they need to move because because they're too scared to stay. And we don't want that. So, so you can, if those circumstances are met, and I think, Allison, I'm going to let you kind of talk a little bit more to the alleged offender and how that, kind of what's at risk for the company.
Yeah, I mean, I agree that it's possible to reassign the complainant, but it's something that you want to be very careful about because that can look retaliatory. And there have been lots and lots of cases filed over the years with exactly those facts. So this is a scenario where I think you would want to be getting some legal advice before you acted on that, potential remedy of moving the complainant, and be prepared to have your employment lawyer tell you that you should do something different if you want to avoid potential liability.
Yeah, excellent. Thank you. Okay, and so our very last question here is, before we move on to questions, is what do I do? What if the outcome of the investigation is inconclusive? And the answer to that is that's not uncommon. And what you're going to do is this really becomes an issue of culture. So if there are conflicts and issues coming up that we can't conclusively determine as being harassment or discrimination, but instead we determine it's just a conflict and where folks are not getting along with each other, they're having problems they're not able to work out, it is imperative that you do still continue within that problem-solving mindset and find a way to figure out what the problem is and find a way to solve it and find a way to help the two of them get back to work. And so, as I tell employers all the time, we are not medical professionals, we are also not licensed therapists. So it isn't a matter of talking things through with people about, what are their emotional or historical or reasons for why they're acting certain ways, or kind of what those issues are. You want to be empathetic and sympathetic, but you always want to come back to, hey, how do we get back to work? And how do we solve whatever problem is going on here at work so that we can get back to work? And so I think approaching it with that mindset is what I think is really important when investigations are inconclusive. And it also Allison, you can share a little bit more about this. This is also a great opportunity, even when there's nothing that's happened, it's a great opportunity to do respectful workplace training, where we talk about how we treat each other, and we talk about communication, and we talk about expectations for behavior, as well as behavior that's not going to be that we aren't going to allow discrimination or harassment in our workplaces, and how to address that. So Allison, what would you like to add to this?
Yeah, I think the only thing I would add here, Nicole, is that so many investigations do come out as inconclusive. He said, she said, or he said, he said. And I think I agree with all of your points. And I guess the additional point I would make is that it's really important to make sure that both the complainant and the alleged offender have been reminded about the company's non-retaliation policy, and that the complainant there's follow-up with the complainant for a period of time after the resolution of the complaint. I mean, this would be true for any complaint, no matter how it's resolved, that you're checking back in with the complainant for, maybe 6 months, and maybe it's once a month to see how they're doing, make sure there are no, additional issues, documenting those follow-ups, so that you have a record of showing that you took prompt and effective remedial action, and that there was no additional harassment or discrimination reported during that time period. So I guess those are the additional points I would make.
Awesome. Perfect. Thank you. So the very last is follow up, just as Allison really just touched on this, is follow up. Ensure that you're following up with your complainant about what is happening and what remedies are being made, if any. Again, you don't have to share absolutely everything, just what may be appropriate. And then during and after the remedies, make sure you're checking in to ensure that behavior has stopped and that the complainant is satisfied with the outcome. So finally, we wanted to share that the Bureau of Labor and Industries has this excellent technical assistance service. And we'll have a link and all this information also. This is in the slides that we're going to share with you, but you can rely upon them for trainings and updates and, handbooks, postings, things like that. You can also call them about compliance questions, and, have no fear. They don't track who calls. And even if they do know who you are, they don't report to the enforcement arm of BOLI. They don't even communicate with them. So there's no risk there's absolutely zero risk of any trouble coming your way from BOLI. So, okay. So thank you so much. And I think I'm going to stop the screen share here and see if there's any questions we have.
Thank you so much, Nicole and Allison.
Yeah.
I've been monitoring the chat, and I haven't received any questions. We've got 4 minutes left. Allison and Nicole do have to leave right at 2. So if anybody out there has a question, if you want to raise your hand and ask it live, otherwise feel free to type it into the chat. You guys have obviously done such a great job of anticipating people's questions that you've answered any questions they had. Well,
thank you. This has been really wonderful. And It's fun. It's always really fun working with Lori and Allison on these projects and to be able to provide you with some meaningful education. So I'm hoping that this has been great for you. And of course, always anyone can reach out to me if you have any questions. So Allison?
Here is a question, actually.
There is a question.
Oh.
So do the designated persons have to be specifically listed by name in the policy? That's a great question.
So I'll take that one. So they don't have to be listed by name. I usually recommend that, or what I've been recommending to clients with the new policy is that they list the individuals by their title. So, you know, HR manager, HR director, you know, general foreman, general manager, I mean, whoever it is, you want to put in their titles. I think it's risky putting in names because then somebody leaves, you know, then they go, well, I don't know who to go to. It says to go to Sue, but Sue's no longer here. And so I think it's just better to put in titles.
Fantastic. Thank you so much. Okay. Any other questions in our final 2 minutes? If not, I want to say thank you again to Allison and Nicole for taking the time to educate us. This has been great information. For those of you who want to share this with others, or for those of you who we let in a little bit late, we did record the session today, and I will be making it available on the PMCA website and also emailing you a link as soon as it has been processed and downloaded. The slides, as well as the BOLI sample policy and the guidebook that Allison and Nicole walked you through, have been emailed to all the participants in today's call as well. So feel free to share those with others within your company.
Thank you, Lori.
Thank you, everyone. Thanks for everyone for attending today. We really appreciate your time, and have a great rest of your day.
You too. Thank you.
Thanks. Take care, everyone.